hearing aid that just left.
I wondered, and based on, okay, so it now makes sense. It may have been one of the people in the courtroom, so, and that person has now left. So, I think we've got it solved, so thank you all. We're, ready for our last case, of the day, last case of the afternoon, Story Mountain LLC versus Ashco. That's case number 2024-2480. Are you Mr. Humbert?
Yes, Your Honor.
Nice to meet you in the courtroom today. Um, would you like to reserve any time for rebuttal?
5 minutes for rebuttal, please.
If we're ready, with the recording, we can, move forward.
Thank you. May it please the court. Paul Humbert for the appellant, Story Mountain. So jumping to the three-pronged test here under 1.540B, we don't need to discuss the meritorious defense because it was conceded. It's a very low standard to meet that. You file anything pretty much. And, there's some cases that talk about general denials not being good enough, but I didn't dispute it in the trial court. And I'm not going to dispute it here. It's a conjunctive requirement. I know many trial judges over the years that have seemed to, implicitly, if you meet the meritorious defense, that somehow finds a way to morph into the other two prongs. And it's just not what the rule says. And I believe it's what happened here. I want to address it's not in the exact order that my initial brief is. My initial brief has the excusable neglect argument second, but I'd like to address it first here. The trial court, and there's a case that's cited. It's the most important case on this point. It's from this District Court of Appeals. It's the Joe Lynn Inc. versus LRG Restaurant Group case at 696 Southern 2nd, 539. Again, Joe Lynn Inc. We cited in our initial brief. It's not discussed in the answer brief. And that case is on all fours with what we have here. So we have a plaintiff in the Joe Lynn case.
And just so I understand, Mr. Humbert, and maybe this case says exactly what you're about to tell me, but here we have a vacator of the judgment by the trial judge. Did it happen in the Fifth DCA?
Exactly. The Fifth DCA found that the trial judge in that case had abused his or her discretion and reversed. And I acknowledge it's an abuse of discretion standard.
Well, and as I understand it, and please correct me if I'm wrong, boy, is it an abuse of discretion standard. It looks like, emanating from some older Supreme Court of Florida cases, it may be a gross abuse of discretion standard.
So this court addressed that in Emmer versus Brucata. I don't have the citation. It's not cited in anybody's brief. This court addressed that. That case, I believe, is in the last 20 years and said that it's surplusage. The Florida Supreme Court did use the term gross in a 1962 opinion, but that literally the Emmer case says that was surplusage. There's nothing in the case law that they believe that there's a different standard. There are judges who have said, well, just the term gross, implies that it's some heightened standard. But this DCA said in the Emmer versus Brucata, I might be pronouncing the Brucata wrong, but
no, that's helpful. The standard's important, Mr. Humbert.
Standard is important, but the court was operating under the same abuse of discretion standard in the Joe Lynn case, which is why I think it's very illustrative. So in that case, the trial judge did exactly what the trial judge did here, which was they vacated their own final judgment. And in that case, I'm just going to give you a quick background because the facts here are much more indicative of a complete lack of excusable neglect than in the Joe Lynn case. So in Joe Lynn, the plaintiff serves the defendant with a alter ego lawsuit, claiming the two restaurants that the plaintiff was suing, that these two restaurants are an alter ego of one another. That's done on September 4th, 1996. 19 days later, so within the window to file a response of pleading, the defendant, who's also a corporate representative of the LRG group, same here with Ashco. Ashco is a corporation. Here we have a corporation in the Joe Lynn case. The defendant responds with a letter that they fax and send certified mail. This is before 1997, so just before email. They send these to the plaintiff's lawyer and say, hey, we're not one and the same. These restaurants have nothing to do with each other, so it was a sloppy attempt at an answer, but it was, the equivalent of a pro se answer. This court was unequivocal. If you have the benefit, you have taken the benefit of being of structuring yourself as a corporate entity. You don't have the luxury of taking that limited liability in one hand, and then in the other coming and saying, well, I'm ignorant of the law. And
Well, but don't we have here, Mr. Humbert, what was characterized by Judge Wallace as a reasonable misunderstanding? And he actually found Mr. Ashurian, his words, not this court's, to be credible in his reasonable misunderstanding. So that sounds different than what you're describing to us.
it's not, because the appellee who ended up, it was reversed obviously by this court in the Joe Lynn case. They made the same argument that, hey, I thought that it was reasonable for me. And that's what the trial judge in the Joe Lynn case that was overturned thought as well. Hey, I was reasonable in assuming that my letter to the plaintiff's counsel acted as a defense that would then preclude the entry of a judgment.
In our opinion, and I'll certainly read it when we're done here, but in our opinion that you're referencing, does it say the trial judge found that testimony to be credible?
It does, but only if, this is where it's very important. This is going to be on my next point, but I'm glad you brought it up. Judge Wallace referred to that there was a disputed conversation between myself and the representative of Ashko, Mr. Ashurian, when he called my office early on in the proceedings. So writ of garnishment served in November of 2021. Mr. Ashurian calls my office sometime in the beginning of January 2022. It's undisputed. I agree. We spoke. Judge Wallace, if you look at the transcript, Mr. Ashurian's testimony was that that I didn't inform him that he needed to hire a lawyer, therefore he was okay. And Judge Wallace, you can 100% accept Judge Wallace's finding that Mr. Ashurian's testimony was credible on that.
We have to, don't we?
We have to.
Okay.
But it doesn't answer the dispositive question, because he didn't, and this goes to the presumption of service that Judge Wallace never addressed. And I believe the discretion was abused by the trial court in not addressing it. And so when what the conversation entailed, Judge Wallace found that it was reasonable that Mr. Ashurian may have thought that the matter was resolved. That's what the order says. But make no mistake about it, the order does not go further than that. The order never addresses the 7 court pleadings that my office served on Mr. Ashurian. It doesn't say that the trial court order never addresses those. And the trial court order says, it doesn't determine. The trial court says, okay, well, these documents, Mr. Humbert testified that his office serves them, and my office manager testified that we serve them in as we state in the certificate of service. But Judge Wallace never makes a determination as to who.
Well, and stop me. I've got his order in front of me. My recollection of it, though, and I can find it if you don't recollect this, Mr. Humbert. My recollection, though, is he not only found Mr. Ashurian to be credible, he also found credible the fact that he said he only received 2 documents.
He acknowledges he doesn't have a finding that that's credible, because he would have to have said that my office did not send the documents. This is where the presumption, and it's argued in the answer brief that I never.
Well, couldn't you have both? Couldn't you have a situation? I know your point is we send a lot of documents, but just to say hypothetically, you send one document and the other person says, well, I never got the document.
Correct.
Couldn't it be I sent it and they never got it? I mean, are they necessarily mutually exclusive?
They're not mutually exclusive, but the presumption is that and it is a rebuttable presumption, albeit a difficult one. The case law is clear that it's a presumption that the documents were served. Nowhere in that opinion does Judge Wallace go into the presumption. It was ignored by the trial court. I brought it up in my closing argument. It's in the transcript. We cite to it in our reply brief exactly where now in the answer brief, the appellee says that it was waived in the lower court. I vehemently disagree with that because I was there in the trial court. I said it. It's in the transcript. I said, Judge, there's a presumption that these are valid, and that's never addressed in the trial court's order. The trial court simply says, I find that because Farsi is Mr. Ashurian's first language, although he's lived in the country for many decades. I spoke to him. He speaks perfect English. It may be a little bit broken, but it's good English. He said, because of that, I can understand the confusion when him and Mr. Humbert had a conversation. Nowhere in that trial court order are you going to find we believe that, or the trial court finds that those documents were never received. There is a recital where the judge mentions and it goes over the background, but you'll notice there's no distinction. There's no talk about presumption. There's no discussion of who was right and whether they were received or not received. It simply states in a one-line conclusory way that, not even a conclusory way, it's a background fact. Mr. Ashurian states that he only received 2 documents. But there's no, if you apply the presumption that it was legally required to be applied.
So and thank you for that, Mr. Humbert. So it is, and I remember reading that. He stated that at the hearing, Mr. Ashurian, that he only received 2 documents.
So it's interesting. It's obviously, again, I understand we have to accept the findings of fact. I don't believe there's a finding of fact one way or the other on that. But Mr. Ashurian was pretty clear that so there were 7 documents served. He says, I received the one from your process server, and I received the last one, the final judgment, but I received nothing in between.
So he did say that.
Except for the request for admissions, he was the testimony is very cryptic. So I asked him, and he says, well, I don't recall, I'll get you the exact quote if you want, but it's something along the lines of like, I don't recall receiving it. It's a bit of a hedge. And, but if you look at this through the lens that the trial court should have looked at it through I should have been given the legal presumption I'm entitled to. It's clear on the face of the order that I was not. So the presumption is that these documents were served. Imagine all the effort that went through. I mean, on page 17 of the brief, we outline the 7 documents that we served. Okay. To this day, the subpoena for bank records that would have proven the meritorious defense and the employment records, those have never been served.
So you get a presumption, but it's a rebuttable presumption. He testified, that's testimonial evidence, and the judge found it credible. What are we arguing about?
He found it credible that he was confused about the conversation we had in January of 2022. He never found it credible specifically and never discussed the presumption regarding the documents. He makes reference that was his testimony, but there's absolutely no discussion about, because if there's a rebuttable presumption that I sent him, could any reasonable person conclude, we don't know because Judge Wallace didn't say, could any reasonable person conclude that those 5 documents that Mr. Ashurian says he doesn't get, and it's understandable why he'd say that because it would be the death knell to his case. So it's understandable that you would not want to testify to that.
But the judge did find him credible, and he did testify that. So if he testified that, the judge found it credible, then your presumption is gone.
But the case law says that simply
Unless
testifying that you didn't
unless
receive
you're asking us to reverse the judge's finding.
I don't believe the judge made a find. The judge did find him credible as to a very specific conversation where the judge makes no mention of was I credible or not. We don't know because there was no presumption. The judge, the trial court should say, I find Mr. Humbert's testimony, despite the presumption, to not be credible, and my office manager to not be credible, or to say that given the circumstances, right, that given the circumstances, there's enough here that I believe that that the presumption was overcome. We cited in our reply brief the case, I believe it's the Bergens case, I could be mispronouncing it. It says that simply saying you did not receive is not enough to rebut the presumption. It can be if there's other evidence, in the record. But here, that's not what Judge Wallace was doing. He's simply looking at.
Weren't there different service mechanisms? Some of the documents, for example, just the e-portal, e-service portal.
The only document is, and there's no requirement that we do it. My office never does it just because it's not required under the rules, and it's the actual clerk's default is the only document that's not. Sorry, and I acknowledge that it was never. I don't claim to have mailed it. The clerk didn't mail it. I agree. And in the Joe Lynn case, which again I urge this court to. Do you want to stop?
Sorry about that. Please proceed.
In the Joe Lynn case, it's the reason that case is so important is the Cedar Mountain case that's relied on primarily regarding and that's the second issue that I'd like to address, which is the due diligence. The excusable neglect is addressed in Joe Lynn. If you look at those facts and you look at our facts, the Joe Lynn, the losing party in Joe Lynn, the defendant, he didn't show up to the hearing because he thought, I was excused because of the letter that I faxed that said that these entities are not the alter ego. He thought that his informal communication with the attorney excused his compliance. That's exactly what Mr. Ashurian did, except it's worse because it was a phone call. It wasn't even a court pleading. Why would anybody think that after we had a phone call, if this thing was really resolved like he believed, why did my office serve him 5 consecutive pleadings after that? That doesn't make any sense. That is an abuse of discretion. And I agree that's a heightened standard. I think that we win because the finding's not there, the rebuttable presumption is not addressed. That's more of a de novo issue. But even if you really want to pick apart and do, hey, abuse of discretion is a heightened standard, these are unreasonable findings. It's an unreasonable finding to say that an attorney that I say in a certificate of service, and the reason I take umbrage with it is because it's my firm, and if I say I mailed something, I mailed it. And my firm and my office manager is the same way. And we mailed it, and this gentleman comes in and says, "Well, I don't know, I didn't receive it, I don't recall." Very ambiguous. So I agree that it's a very heightened standard to find that the judge abused his discretion in the findings of fact. But if you want to assume that Judge Wallace, if we want to say, hey, he did give you the presumption, although it's not addressed in the order and it's clear that it wasn't done. But even if we give every benefit of the doubt and say that the presumption was given and that he really weighed the testimony between my office and Mr. Ashurian, if we want to give all the benefits of the doubt in favor of the judgment debtor appellee, it's still an abuse of discretion. It really is. And that's exactly what the court did in Joe Lynn. So it is an abuse of discretion to find those 7 documents. So why would my office, if we really are in the game of not mailing documents that we say we do, the document that would have been convenient not to mail would have been the final judgment itself. So we mailed the final judgment and we personally served the garnishment, but all these documents in between we never sent. It is the epitome of an unreasonable finding. But again, that is a secondary issue. The main issue is that we were never afforded the presumption by the lower court of the validity of the certificates of service. The finding of credibility of Mr. Ashurian is only as to that phone, is only addressed, and you can read the order, and I've read it many times because I figured you guys would ask that question, but it's only as to the phone call that he had with me. And I agree with Judge Wallace on that, by the way. I can understand where somebody would be confused if you're not an attorney. I don't think it's excusable. There's a whole other line of case law we cite on that. See, you have the limited liability that you take. It's not a constitutional right to incorporate as a corporation in this country, in this state. It's a legislative gift. And so you have the right to protect yourself from creditors and everyone else by incorporating. And you have an in-house counsel. This is all in the record. They have in-house counsel, multiple in-house counsel. One of them is here today. Outside attorneys, accountants. This is all in the record. It's all in the cross-examination of Mr. Ashurian. This is a sophisticated commercial entity that owns and their affiliates own numerous commercial properties in the state of Florida and in this region. But yet they're excused from having to comply with any court, never even producing a single document responsive to a subpoena, and then just showing up. And I know I'm eating in my rebuttal time, but I want to make one final point. The due diligence, there is nothing diligent. So if we went on excusable neglect, which I believe we do, especially after the Joe Lynn case, and I should have made a bigger deal about it in my brief, candidly. I should have been given even more discussion, but we do cite it on page 9 and 10. If the due diligence, there's nothing diligent about filing a unverified motion and then waiting until the day of the hearing, 67 days later. That's not obviously Mr. Gowdy's firm has nothing to do with this. This is a separate trial counsel.
Well, in the whole unverified thing, and try as I might, I don't see a word of that in the rule. Not a word about having to verify the motion. I mean, you strike me as a smart person, Mr. Humbert. I mean, the rule doesn't require it to be verified.
It's not specified in the rule, but the case law, a lot of the one case that says that it doesn't is a per curiam opinion from this court, which is their best case.
Well, but no, I hear you, but we have a rule dedicated to this issue and another rule, 1030. I mean, that says, unless we say otherwise in these rules, there is no verification requirement and no affidavit requirement. Wow. I mean, so, and I know there are rules. Sham pleading is an example of where you have to have a verified motion, but there is no requirement in this rule that it be verified or that affidavits be appended to it. So, I mean, cases that say that, with all due respect, I disagree with it because I think the rule just doesn't require verification. Now, perhaps your argument is beyond that. Perhaps you're saying, even if you assume it didn't have to be verified, it was still not diligent of them to handle it the way they did. But help me understand, if it's not in the rule, how it's required.
I'm going by what there's the case law says that. I agree. I'm a textualist myself. I don't, I'm with you. It's not a statute, it's a rule. So I think there's a little bit more liberality with it, but the case law says that. I didn't go back and look at the origin of why they said what they said.
I
On the
just.
other side, I'd probably be saying the other.
Well, and 103.0, I mean, if we don't say it, you don't have to do it. So I think that's game, set, match, but, I hear you. So tell me beyond, what the rule requires, and we'll give you a couple more minutes, Mr. Humber, because we have asked you some questions. But explain to me, if we assume it doesn't have to be verified, and I think the rule's clear on that, and no affidavits have to be appended to it, why, this law firm, this entity was not diligent in trying to set this thing aside?
Because even under the Applebee's best case, which is the Cedar Mountain case, it's their best case. My best case is Joe Lynn, their best case is Cedar Mountain. I agree. It's a per curiam opinion, and it goes against some of the other opinions, but it was from this District Court of Appeals. But that opinion even says that if you're talking about the it says what you're saying, Judge, which is, hey, it doesn't necessarily have to be verified. It can be supplemented, sort of thing. That opinion says that the motion itself still needs to recite facts that, if proven true, would support a finding of excusable neglect. If you pay very careful attention to the original motion filed by the trial counsel for the appellee, you're going to find that an averment of that they're not indebted. They addressed the meritorious defense that the original judgment debtor wasn't indebted, that he had passed away at some point near the end of before, right after the writ of garnishment was served, but shortly thereafter. And that upon the appellee being notified of the final judgment on May 10th, 2022, that 9 days later, they filed a motion. There's nothing about those 7 documents. This is why they do blend in with each other, the excusable neglect and the due diligence. There's not one word in that motion that discusses hey, I didn't get any of these documents. Nothing about why those documents were all ignored. Or the fact that 2 years later, we're now 2-3 years later, and they still hadn't produced documents that we had lawfully subpoenaed. So there was not one word about that. It doesn't meet the requirement of even their best case, which is the Cedar Mountain case. So if you look at that original motion, the original motion to vacate filed by trial counsel, it's just not there. It doesn't even meet the Cedar Mountain requirement. Again, if Your Honor's taking the position that the affidavit or a verification is not required at all.
I'm not taking that position. The rule takes that position, but go ahead, Mr. Humber. Thank you.
So if we accept that premise, the due diligence argument there is much more favorable for them than it would otherwise be. I can see that, but they don't win on excusable neglect. They can't. If somebody can find me an example of more inexcusable neglect than ignoring all of these court papers, and if the trial court had provided me the presumption that I requested and addressed it then I agree that I would have a much more difficult burden, because that would be a straight abuse of discretion, and that would be hey, look, maybe we don't agree, but we're not here to change the facts are the facts, and this is not a trial court, this is an appellate court. But we don't even get there, because they never even talk about the presumption in the trial court order. That's the original sin.
I have a habit sometimes of asking questions that I admit have no relevance to your legal issues, but I do just kind of have to know, has anybody confirmed is or is not Mr. Ireland actually deceased?
There's a death record, so I'm going to assume.
Okay.
Yeah, he died on December 28th, 2021. So a few weeks after the writ was served. Correct.
Mr. Humbert, I want to be true to my promise. I'll give you 2.5 minutes for rebuttal. That means Mr. Gowdy has 2.5 extra minutes as far as his argument is concerned. But if you are finished, I'll give you 2.5 minutes for rebuttal.
Thank you.
Thank you, may it please the court. The death certificate is in the appendix. It's there, and I can get the exact site. And it seems like we all agree he died on December 28th of 2021. I just want to start by saying this is the first time I've argued against somebody who was a witness, trial counsel, and appellate counsel. And I appreciate Mr. Humber's passion, but a lot of I know the court will do this. You'll parse through when he's conveying personal knowledge to you and what's actually in the appendix. I was neither trial counsel and I was not a witness. Just one example, he told you there's all this evidence that the company has all these lawyers. It's not in the appendix. Mrs. Shurian is here. She is counsel. her name's not mentioned anywhere in this record. So I don't know why he felt the need to tell you that. And I think there's lots of other examples, but I won't have time to go through them. We just ask the court to look closely at the appendix. I want to start big picture, and I want to start with the text of the rule, Judge Jay. I think you've identified it. And I want to, the three-part test, and we're here only on two of them. You have excusable neglect and due diligence. And I would like you to look at the rule to see where those two elements come. And it's Rule 1.540B, and under subsection 1, it's, well, let me start actually under the heading, or the B part. It says the court may relieve a party from a final judgment, that's what we're on here, for the following reasons. And then under 1, it has mistake, inadvertent, surprise, we're not on any of those, or excusable neglect. Okay, so that's part of it. Now, where's the due diligence in the rule? Well, if you jump down, you'll see the motion shall be filed, not prosecuted, filed within a reasonable time. And it says for reasons 1, 2, and 3, which we're under 1 here, there's a cap on that, 1 year after the judgment. Now, I'm going to jump to his first argument in the brief and that he finished on. The way I think of this temporally is excusable neglect is everything up till the final judgment, which in this case was May 10th of 2022. And the due diligence is everything from the entry of the final judgment to when you file. So that's what the rule says, file the motion to vacate. The motion to vacate was filed 9 days after the final judgment. And it was filed by the undisputed affidavit in the record from Mr. Alan Ashurian. It was filed 2 days after receipt of the final judgment. So what you hear about the due diligence argument that you heard at the end are about events that happened after the motion to file, the final, motion to vacate. And how that, Your Honor, respectfully, none of that falls under Rule 1.54B. What that might fall under is the court's case management powers under Rule 1.420E, which deals with a failure to prosecute. And if you read what Judge Wallace said at the hearing, he apologized for how long it took for this to get decided. He said, I regret the court's role in this and the participation in this. There's no excuse for the lack of action. And I'm not here to, I like Judge Wallace, I'm not here, but there were some administrative mistakes. It's all documented. Mr. Alexander, who was trial counsel, filed an affidavit about the numerous emails that went to the judge's JA, and there was no response, all that. But, Your Honor, none of that has anything to do with the due diligence requirement at all. Because what the text of the rule says is you have to file within a reasonable amount of time. Once you file, then you stop that clock and you fall under the rules dealing with lack of prosecution, which we aren't even arguing about. And I want to make clear one other thing. It's escaping me here, but that we're only here on the motion to vacate. Judge Wallace also entered some orders in this same order on lifting the admissions and discovery and all that. You don't have jurisdiction to review any part of that order. And that's what he's really complaining about, I think. But it's not before the court. The question is whether there was excusable neglect leading up to the entry of the final judgment, and then whether there was due diligence in filing the motion. It's not a failure to prosecute case.
What say you, Mr. Gowdy? You heard the argument about these documents that were sent, according to Mr. Humbert, from his office, and Mr. Shurian said, I didn't get them. Why does that not undermine the excusable neglect analysis of Judge Wallace?
Well, I do think there evidence that undermines the excusable neglect. But the judge, is given deference on the factual findings. And I want to go through those documents because, with particularity. As far as the 7 documents he's
Let me-
talking about.
Let me real quick pick your brain on standard of review. I know our standard review here is abusive discretion, perhaps with some surpluses, maybe gross abusive discretion. Is that top down for the entire issue? Are the constituent parts of the judge's decision also under that same standard of review? Specifically, where a judge finds that something is excusable, is that a question of law, a question of fact, or a question of equity? Should we be looking at that for abusive discretion, or should we be looking at that de novo and then deciding the ultimate question as abusive discretion?
It's all abusive discretion. I think the only thing that would ever probably be de novo in this context, which he's conceded on, is the meritorious defense.
Well, I think your opponent would say that based upon the case law he has, that our review would say that you can't have a reasonable finding that this was excusable, thus it becoming a question of law, which I think we would review de novo, and then that constituent part of the analysis would inform whether it was abusive
Well,
discretion or not.
I guess the way you framed it, you can always frame something to make it de novo if you're gonna, I mean, it's sort of like when you're reviewing a jury verdict. You're saying, as a matter of law, de novo, could a reasonable jury reach that finding? So if you want to say you're reviewing whether the judge had a reasonable finding, and you want to call that de novo, I guess, it's just like, but you're still got to give deference to the finder of fact. And I kind of want to get into the, about that, because in the reply brief, Mr. Humbert cites the Scuteri case that he talked to you about a minute ago, and this gets into the presumption that you're bringing up. And I would just say those documents only deal with excusable neglect, because all the documents he's talking about were served before the final judgment, so they don't have anything to do with the due diligence, okay, which was only a 9-day period, when we received it. But first of all, he keeps telling you 7. 2 of them are the same. They're the original writ with the subpoena that was served on Mrs. Ashurian on November 29th, 2021. And you're right, you read it in the order. We conceded that we received that, but he lumps those together to get to his 7. And then the last one that we concede we received is the final judgment, which we reacted very quickly. Got it to council the same day. That's Mr. Alan Ashurian's affidavit, and the motion was filed 2 days later by the ADB law firm. So the 4 documents in the middle that he's making a big deal of are the request for admissions, 2 notices of hearing, and the motion for entry of final judgment. And he's saying, hey, I certified by mail that they were served on Mr. Ashurian, and therefore we're going to presume that they were received. And that's true. He didn't quite articulate it this way below. There's only one sentence in the entire record where he's preserved this argument, if at all. And I'm going to tell you in a minute why he hasn't, but I'll just concede that for now. And he threw the word out prima facie, which means if you look it up in Black's Law Dictionary, it can be rebutted. And actually it says it in the case he was citing to you, Scuteri. Because so he reads this part of the case. This presumption is not overcome by denial, even though sworn that the order was not received. So he's quoting that to you. Turn the page. In other words, the denial of receipt does not automatically overcome the presumption, but instead creates a question of fact which must be resolved by the trial court.
And you're saying, Mr. Gowdy, Judge Wallace resolved that issue of fact?
He did, as you've already pointed out. He says, it's Appendix A8, page 3 of the order. He says that Ashurian denies receiving, and he lists the documents. And then he says, he testified, the only 2 letters I received regarding the garnishment were the original notice and the final document. And actually, he didn't just say, I didn't recall. Maybe that's his memory of it, but that's not what I'm reading from the transcript. you can find this all at appendix 291, 293. He said, I have not received anything. It's not some equivocation. I recall receiving 2 documents from you. One that I immediately called you on. He's talking to Mr. Humbert. The second, I immediately formed through my son to give that document to my attorney. Those are the 2 documents, original garnishment and also a letter that said garnishment was completed. As soon as I got the letter, I think he's referring to the final judgment, those are the only 2 letters I got, Your Honor. That's what he testified. And Judge Wallace then put this statement in his order. And so what are we hearing now? We're hearing that Judge Wallace didn't make explicit findings that that statement was credible. Well, if he wanted to preserve that argument, which by the way, he only really raises that for the first time in his reply brief, he throws out this presumption in the initial brief, but then at his reply brief, I got it here, he throws out, so on the bottom of page 4, he goes, but the 4 corners of the order make clear that never occurred. The trial court's failure to consider this presumption of service is violated. So now he's complaining about the 4 corners of the order. And I will say we didn't brief this because it came up in the reply brief, but that's saying if you're going to complain about the findings in the order, you got to file a motion for reconsideration or rehearing, which he never did. And that's what this comes down to. So I think this is all.
So even though he verbalized the argument, he didn't file a motion for rehearing, reconsideration.
No,
So
sir.
therefore, that argument has been waived.
Yes, sir. Correct. Never. And he raised it for the first time in the reply brief. Because what he's not, all he raised in the initial brief was the presumption. But what he's really complaining about is that the judge's findings weren't more specific. I also want to go, we're seeing this repeated here today. So he got up on oral argument and told you that the Joe Lynn case was his best case for excusable neglect. In his initial brief, Joe Lynn is cited only on pages 9 and 10, and that's under the due diligence argument. So no wonder we didn't address it in our answer brief. And I just did a word search through the appendix. It was never cited below. So now he's shown up at oral argument to tell you that this is the best case for him. I don't know if you want to call that preserved or not, but it's certainly not really what I'd call fair tactics. But I got a chance to read it, and what happened in the Joe Lynn case is there was not an argument that the matter had been resolved. What the party served had said was, we thought our letter would be construed as an answer. That's not our argument. That's not what Judge Wallace found. He didn't find that Mr. Ashurian thought he had answered the writ of garnishment. Mr. Ashurian, a non-lawyer, who, as long as he's been here, Judge Wallace is finding, despite he gave you personal testimony about what he thinks Mr. Ashurian's English is. You heard that today from this podium, completely improper. Judge Wallace made a finding on that. You have to respect it. Mr. Ashurian was of the opinion that the matter had been resolved based on the conversation. And if you read the transcript, one of the things that got brought up was that he kept faulting Mr. Ashurian for saying that he didn't know Mr. Ireland. He was offended by that. Counsel was, witness was. And Mr. Alexander tried to suggest to the judge that what Mr. Ashurian might have been saying is, I don't owe Mr. Ireland any money. No, owe. And the record here, I know he doesn't want to talk about the meritorious defense, but it is worth, I think it's part of the, it is part of the analysis.
Well, and let me, I had planned to ask you this. I will certainly ask Mr. Humbert this and give him the time to answer it. There seems to this judge, I can't speak for my colleagues, there seems to this judge, and doing a jet tour through the federal cases last night too, an equitable component to the rule. And talking about terms that are just, for example, to be one. Is there an equitable component to the analysis by the trial court in a B1 analysis, 1540 B1 analysis?
Yes, I think so, because of the terms of art that are used there that are very broad: mistake, inadvertence, excusable neglect. And the case law certainly talks about,
And the Fed, just to let you both know, the federal cases categorically say that this is quintessentially an equitable analysis. And so I saw there was some mention by Mr. Humbert, I believe, either in his initial brief or his reply brief, about the statement by Judge Wallace that, let me see if I can find it, that he just wanted, the court cannot help but observe that a refusal to vacate the garnishment judgment would result in a significant forfeiture or sanction being imposed on ASHCO, et cetera. This is on page 8, yes, and he took exception with that. But again, if there is an equitable component to this, is that not somewhat part of the analysis? And that's my question, Mr.
well,
Gadd.
that's why the meritorious defense component is there, and he doesn't want to talk about it by stipulating to it. I will say the meritorious defense element is the only non-textual element of the three-part test, because it's not in the rule. I do think it makes perfect sense, because if you don't have a meritorious defense, why are we vacating the judgment? And I think it's the reason the courts have considered it is for what you're getting into. And let's just say it, Mr. Ireland was not our employee at the time. There's no evidence that he was. There's no evidence of any unpaid wages. This is a 2013 judgment, when at that point in time, Mr. Ireland was associated with ASHCO, and they're trying to, and he died less than a month after this writ was served.
So
And they're trying to collect $500,000 from ASHCO for that.
Is that part of the trial court's analysis?
Yes.
Mr. Gadd?
Yes.
That,
Sorry
that's
if I didn't
big.
answer that directly.
No, that's, thank you for being direct. I must ask Mr. Humbert the same question.
There's nothing wrong with that. I don't think court judges should bury their heads in the sand as to what's really going on here.
That is, so you would say that's baked in the rule. Then the federal cases, the Federal Circuit Courts of Appeal, arguably the SCOTUS has said it's baked into the federal rule, which is substantially similar, maybe identical. I didn't go word by word, but
It is very similar.
Yeah.
It's Rule 60 under.
yes, and B1 is, I think, identical. And the cases, again, are legion, saying that equity is a feature. Second question, Mr. Gaddy, and I will ask you that same question, Mr. Humbert, in a minute about the equitable component. Gross abuse of discretion.
Right.
Is that a thing or not? Is that our standard here or not?
It's what the Florida Supreme Court said. In all candor, I'm not a big fan of adjectives and have never understood when that word is tagged on to things.
Never
but it is-
strenuously objected?
Right, like I heard he said he vehemently didn't disagree with something. I've never understood the difference between that and disagreeing. But it is what the case says, is all I can say, Your Honor. I don't really think that's, I think.
Is it of no moment?
I wouldn't say it's of no moment. I think it shows that you are dealing here, as you just said a moment ago, there's an equitable nature of the rule. I think there's excusable neglect and due diligence are broad terms.
Well, and this judge, I can't speak for my two wonderful colleagues, but this judge thought maybe that's a part of this, that maybe that higher standard, and you're right, I'm not sure why that word tagged on to abuse of discretion, but maybe that presupposes some equitable component to this that this court needs to be deferential to the trial court about, perhaps. And I don't know if the cases say that. I candidly have not read these older, I think there are at least 2 Supreme Court of Florida cases saying that.
Yeah, we cited obviously here when we say the standard of review. I'm not going to back off of it. But I think really this is an easy case to decide based on just the record. One of the arguments in the initial brief was, which you heard today, is that it's just not credible what Judge Wallace did. Well, y'all on an appellate court, you're not here to make credibility findings, but that's what's being argued to you. And so whether you want to call it gross abuse of discretion or abuse of discretion, or even de novo, you defer to the fact finder and all those standards. And he just doesn't like the finding of fact that Judge Wallace made that,
We're not here to make the credibility determinations, but we are here to determine whether those credibility determinations were legitimate. So our
Correct.
big question is, how much deference do we give when
Sure.
determining that?
yeah, so I think, like, when you're talking to this case, you know, you hear the whole, he said, she said, this is Mr. Humbert talking to the principal of my client, Mr. Ashurian, on a phone call, and what happened with that. So to me, unlike the case you just heard, which dealt with contract documents and a lot of paper that's being reviewed, and what do those words mean? This is the highest level of deference, because it's what was said between the parties. And none of you have observed my client in person. Judge Wallace did. So didn't counsel as a witness, but he's not here today as a witness. He's here as appellate counsel, and he has to respect that Judge Wallace disagreed with his assessment of Mr. Ashurian. And so do you. So I think there's no higher level deference because of the nature of the evidence at issue in this case. To answer your question, Judge McIver, you can't, you're not in a position to second guess Judge Wallace on that. Maybe on that contract case you are. I'm not speaking about the last case, but I think there's just a difference when you're dealing with the evidence. I see I have 24 seconds left, so I think I've covered all the points I wanted to cover. If the court had any, Cedar Mountain, just real briefly. I kept hearing it was per curiam, which simply means it's unsigned. It doesn't mean it's any less authoritative. And I would just point out, former Justice Lawson was one of the 3 judges on that opinion. And all it did was read the rule, which is Rule 1.030. But we'd ask that you affirm the order below. Thank you, Your Honor.
Thank you, Mr. Gowdy. Mr. Humbert, it looks like you officially have 2.5 minutes, but I'm willing to give you a little bit more time to deal with some of the things I brought up with Mr. Gowdy at the end that I said I would ask you about. But let me start with this equitable component. And I know you took exception with that statement on page 8 of Judge Wallace's order, but is there an equitable component here in this rule?
Not in the cases cited in the briefing that I've seen. As far as, and I think if there's an equitable component, it's going to go to the meritorious defense issue, which was.
Well, and I'm just looking. I've got the rule. I know you have the rule on motion and upon such terms as are just. That sounds like equity to me, perhaps. But then we've also got excusable neglect that also has a little bit of a feel of equity. So I mean, that's my question. Is that a feature here? The federal courts say it is. Is it a feature for us? Was it a feature for Judge Wallace below?
I believe it drove his opinion, and it ultimately, but if, the binding opinion on this court is, and I'm not familiar with those specific federal cases you mentioned, but the Joe Lynn case from this district, it doesn't regard equity as a material consideration for the excusable neglect. And I do take umbrage. It was alleged that I didn't raise this in the lower court. On page 118 of the hearing transcript, I said, I not only cited the case, I gave Judge Wallace the citation to Joe Lynn. It was the only case I actually cited the full reporter citation. So I cited it, and the fact that I put it in page 9 or 10 of my brief, it was addressed in my brief. So and also there was a representation that I have made statements that are not part of the record. There, if you look at the hearing transcript, there is plenty of testimony that Mr. Ashurian's wife, who testified on behalf of AASHTO, stated that they have accountants. That's in the record. That Mary Beth Mitchell, who's a name you're going to see in that transcript, that she may have not been a Florida bar attorney, but she was an attorney that worked there. So that's all part. I just wanted to clear that up, that is part of the record. And the fact that the Joe Lynn case, it is a very damaging case for AASHTO here, which is why I think there's a leaning on it being that it's somehow waived. I don't know what more I could do to preserve it or preserve the presumption. It was stated that I only said it once. I don't think there's an obligation for me to repeat
that aside, Mr. Humbert, I think Mr. Gowdy's point is that these facts are dramatically different than that case. I mean, starting with, we have a letter versus we have a conversation that was evaluated by Judge Wallace, meaning the conversation you had with Mr. Ashurian in this case.
I'm agreeing for purposes of this argument. I'm agreeing. I'm not trying to challenge Judge Wallace's finding that Mr. Ashurian and I had a misunderstanding, and that Mr. Ashurian was reasonable in that misunderstanding. Accepted, premise accepted. Give him that benefit of the doubt. I'm not challenging that.
Yeah, but.
That's the he said. It's all he said. He said, I agree. Fine. Mr. Ashurian's right. I misunderstood. He was perfectly in the right. Let's assume that. It's everything that happens after that's documented in all of these court filings that are served. You know what's if we're going to talk about equity.
But Mr. Humbert, that sort of begs the question, respectfully.
Okay.
I mean, if you go back to what Judge Wallace is saying, Mr. Ashurian believed that was it. We don't need to do anything else. So it's, again, of no consequence, according to Mr. Ashurian, if in fact he did receive more documents. I think, can't you read that order that way to say his misunderstanding, purported misunderstanding, was such that he just believed it was over?
I would agree entirely. If that conversation had happened at the end of the litigation prior to the judgment being entered, I would agree with you completely. But it happened at the beginning, and then everything that happened after that completely contradicted what a reasonable person would assume that everything was resolved. It is so much worse. The facts in Joe Lynn are so much more in favor of just affirming. I mean, these facts are more egregious. Joe Lynn is a 3-page opinion. If you go line by line, no, a letter, a conversation, Ashko's conversation with me versus the letter in Joe Lynn. Okay, they both are non-attorneys that are corporate representatives, and they both had a misunderstanding. And even on those facts, the trial court, this court found that the lower court should be reversed. But here we don't even have the 5 subsequent pleadings that occurred after that. And the idea, one more thing regarding the waiver argument, the argument wasn't waived on at any point. Presumption simply wasn't given. There's no requirement in a non-jury setting that a motion for rehearing be filed as to findings of fact. Judge Wallace the presumption was not given, and that was the death knell of the entire opinion. And I think when you read Joe Lynn and you juxtapose it with these facts, the facts in Joe Lynn are worse. They just are. If there had been 5 additional papers that had been served on the plaintiff's lawyer, then we'd be dealing in the same world here, but there's not. So, and that's the only 5th District Court of Appeals opinion that I believe is on all fours as to the excusable neglect.
Thank you, Mr. Humbert. Thank you, Mr. Gowdy. It was very well presented on both sides. We will be in recess.
All rise.